Welcome to Anchored in Law, the Maritime Podcast.
Welcome back to Anchored in Law, the Maritime Podcast with maritime attorney Todd Lochner, founder of the Lochner Law Firm. Todd has spent more than 2 decades helping vessel owners, brokers, and marine businesses manage contracts, documentation, and disputes effectively before they become costly issues. I'm Leanne Lyon, and today we are talking about the legal traps that catch boat buyers and sellers off guard, from missing paperwork to bad assumptions about what's standard in a deal. Todd, when people are buying or selling a boat, what kind of legal issues come up most often that they simply don't expect?
One of them is the existence of prior liens on the vessel. Specifically, a lien, which is maritime in nature, does not need to be recorded anywhere. It might be, but it need not be. And when you're purchasing a vessel, you are purchasing something that may have a lien on it, which travels with the vessel. Because in admiralty law, the vessel is personified and as if a person, and can actually have liens of their own, which do not just attach to the seller and for their account. So it actually travels with the vessel in persona. It's called in rem, but it's an attachment as if they were a person. So that's probably one of the largest things that pops up. People don't quite appreciate that those items are out there. Plenty of war stories. I mean, I had one fellow that was purchasing a yacht only to find 2 days before it closed that there was a yard in, I forget where, somewhere in South America that had lien asserted. There was a captain from South Africa, and then there was another yard in the United States, approximately $450,000 of liens that were going with the vessel. Fortunately, we represented the buyer because the buyer was about to purchase that much liability that ultimately needed to be paid. So those sorts of things are the ones that are the most shocking to people, that they don't appreciate. We've even had scenarios where a vessel has been sold 6 different times, and 6 owners ago, a maritime lien arose, and in that context was actually recorded as well. And ultimately, a vessel owner way down the line was left with the prospect of having their vessel seized.
Wild. And also interesting about the vessel being an entity, much like an LLC or other corporate things, but that's maybe why we call vessels she, correct?
Well, it's certainly, we have a lot of lore that goes with a vessel, calling her and personifying the vessel. But the in rem is something that is unique. It used to be existing in other areas of the law, but it's unique now to the maritime and specifically the admiralty practice. And you might note that I sometimes use admiralty and maritime, and it's really just a connotation. The admiralty connotes the procedural aspects in which courts and things of that nature. So since courts are different when they sit in admiralty, and then maritime is more the body of the law. Also, you will find that people use admiralty more in the blue water context of ships, and people will use the word maritime more in the brown water context or the intercoastal context or recreational.
Fascinating and great definitions. Thank you for sharing that. A lot of buyers think that a bill of sale and a handshake are enough. And so what is usually missing from those informal deals that can cause those problems later, as you've mentioned?
Well, certainly one of the things that always develops is what's the risk of loss? When does that risk of loss actually shift and transfer from one to the other? I've had circumstances where a vessel was in the middle of a sale, and whether the risk of loss shifted on day 1 or day 2 mattered, because the vessel broke free of its mooring and ended up on the Naval Academy seawall, where it sat for 8 months or more on the rocks. And the fight was about, well, it hadn't transferred or it did transfer, and that can be resolved in the contract language. There are a host of other things that occur. It's just one that is rather dramatic, since you don't see a vessel up on the rocks for 8 months. all over this issue of when things transfer. Another area that is a big one is what happens when the money doesn't arrive. I've had this file before as well. Approximately a million. Well, no, I think it was $500,000 on that one. I've had it several times, but one of them was $500,000. One was close to $1 million. Just did not arrive at its seller's bank account. And in those circumstances, you will find that someone has sat there, hacked into either the seller, the buyer, or the broker's email accounts, waits for the right moment, changes the account numbers, and the money never arrives. So that risk can also be solved, and that is something that can easily be solved. The really usual mundane one, though, is simply what's wrong with the vessel. Do you have something's wrong and you want to have it fixed or not fixed, and whose responsibility? And really defining when it is, in fact, an item which will allow you to get out of the contract. Frequently, there are contracts that are boilerplate, but you really don't know what's in that boilerplate until you take a deeper dive. I know I've rambled slightly beyond the original context of the question, so I apologize.
That's good. It's all fascinating. So you mentioned liens earlier. So when a vessel changes hands, who is responsible for verifying that all liens, loans, and that documentation that should be there are cleared?
Well, in all of the contracts that we draft and participate in, which includes the Yacht Brokers Association of America, those contracts we drafted for them. So that's what's used in most of North America beyond the Florida line. And we also did a version for Canada. So in those, for example, we make sure that it is the seller who is required to clear all such encumbrances. So there's an answer to that question, which is whose responsibility, and we put that in the contract. However, there's also a very practical response, which is if you're the buyer, you want to not just take the seller's word for it blindly. So the first thing you do, of course, and I recommend that people do this even before they put in the offer. And for my broker clients, I recommend that when they take a listing, they get, in the context of a U.S. documented vessel, the abstract of title. So for $25 and 72 hours of wait time, you can get a list of what the U.S. Coast Guard has. Now, remember that you don't necessarily have to have it recorded for it to be a good maritime lien, but quite a few of them are recorded. And it gives you good information as well. Like you can reverse engineer more or less what they paid for the vessel if they have a mortgage on it, which is all helpful information when you're trying to purchase from a buyer's perspective. And it helps to make sure there's clean title. For foreign flag vessels, there are similar processes that you can go through and get the similar information. And so that's something that I always counsel buyers to do, regardless of whose responsibility it is under the terms of the contract.
So I'm going to hypothesize that more people buy houses than boats. How different is buying a boat from buying a house or a car, legally speaking, and what catches those first-time buyers off guard about the process?
Well, certainly houses and cars are both regulated more so than buying a boat. There are practically no regulations. There are very, very few. And to the extent that they exist, they are primarily regulations from states who are looking for their tax dollar for the sale of the vessel or the use of the vessel. And every state has their hand out looking for their little piece of the pie. And so that's where most of the regulation comes from, and you have to worry about the aspects of paying tax. First-time boat buyers are often surprised to find that they owe 5, 6, 8% more than they were prepared to pay when they get to the table to close, because nobody told them, oh, by the way, don't forget you have to pay the state tax. And then if you aren't going to pay the state tax, most states have a waiver essentially that says, oh, I'm taking the boat out within 30 days or within 90 days or whatever the circumstance may be for the individual state. And the failure to actually do that and have the appropriate paperwork in order can mean that you have somewhere between a 100 to a 200% penalty. So if you would normally owe in tax, for round numbers' sake, $15,000. And then in the state of Maryland, for example, when it was $15,000, you would get a penalty of 100%. So you would get a bill for $30,000. Then you would get 18% interest tacked on top of that. In the state of Florida, if you get the paperwork incorrect, they will charge you a 200% penalty. So you owe, again, what's that, $45,000. And then they also have an 18% interest as well. So those are the sorts of things that can really shock people if they're not prepared for them. And again, I've gone on a bit long in the tooth. So is there another direction we should go? I don't want to belabor those points because I could go on for each of these questions.
No, it's really valuable information and, points to why it's so important in many cases to consult with somebody in these situations. So let's talk about regulation. I know that regulation can change fast depending on where a vessel is registered or kept. What kind of state or federal rules tend to complicate an otherwise straightforward sale?
An otherwise straightforward sale is one of those things that is a bit of an oxymoron in so much as everything always goes sideways at the 11th hour. Unfortunately, that's just the way you have to prepare for that. However, one of the things that can occur, which is not really a regulation, but I don't think I appropriately addressed it earlier, so I'm going to make sure that I cover it now, is that those first-time buyers sometimes do not realize they're not actually going to be able to use their vessel. Now, why would that be? Well, I'll take COVID, for example. The person wanted to get out on the water. They said, I've never owned a boat before. We're stuck in our home. We have the money to do it, so we'd like to buy a 75-foot yacht as our first boat. And they were well down the path and prepared to move forward when I said, you do realize that you need a captain to run this vessel because no insurance company is ever going to let you operate it yourself, which of course was a bit of a shock and a surprise, which is not precisely regulation, but it is the insurance industry. But it does lead me to regulation, which is that on U.S. flagged vessels, you do have to have U.S. crew. And this doesn't matter for the person who's buying the 40 or 50 foot yacht. But once you get into the 75, 100, 120 foot range, that's a different animal. And you will, even if you are a first time buyer in the 50 to 60 foot range in the current insurance market, be required to hire a U.S. captain to be aboard for the first 6 months of operation if you don't have a robust enough resume. So that can sometimes surprise people as well. And with respect to other regulations, again, the federal regulation that surprises some people is the 1.5% duty. Now, duty and tariff is on everyone's mind. There is a new Lacey Act regulation, however, which is important because any vessel which was built after January 1 of 2008 must now be able to show where every piece of wood originated. And is a separate line even for a laminate. So if you have a table on the vessel that has one layer is wood, fiberglass, another layer of wood, fiberglass, et cetera, then each layer in a laminate must also have its own line saying where that wood came from. And this is both for the protection of the environment. There are also some political ramifications. There are some countries on the OFAC list, which is the Office of Foreign Asset Control, that we as Americans do not want to be dealing with. The obvious ones are, Russia and places of that nature while we're in the midst of this Ukrainian-Russian conflict. But there are also some that are on that list for human rights violations who are places where teak comes from, which is, of course, a popular wood to find in vessels. So any vessel which is built after January 1 of 2008, you now need to comply with the Lacey Act, which is something that surprised in early 2025. It surprised the importers of brand new boats. They were not expecting it. They arrived in January and they said, what do you mean? What's this form? We didn't know we had to fill out this form. So they run to the builder and say, help us. We need to identify every piece of wood in the boat, and we need to identify where it came from in order to import the vessel into the United States. So that's one of those regulations that changes and has surprised many people in 2025, which is now a little less than a year ago, or about a year ago, I guess, that people really had to start dealing with that act.
Wow, that would be a surprise and a complication. Another one can be brokers that use or listing services that have their own contracts. What hidden terms or omissions do you usually see that end up hurting one side of the deal in those situations?
Well, you have to be careful. And there are a couple of form contracts that are out there. The Northwest Yacht Brokers Association, the California Boat Brokers Association, the Yacht Brokers Association of America, and the International Yacht Brokers Association are the big associations that you deal with in North America, including Canada. The California, of course, is used in California. That form, it's a little bit different. The International Yacht Brokers Association has a slightly different form as well, which varies slightly from the Yacht Brokers Association of America form, which is the one that most persons in the U.S., solely by geography, may run into in a brokerage boat context, as well as Canada. We did a Canadian form as well for them. So in the brokerage context, that's the form you're most going to run into. And the other form that is the most frequently found is on the Yacht Closer platform, which is owned by Boats Group, which owns Yacht World website that most people are familiar with because many people will surf Yacht World. There are other listing services like Yachter, which is owned by the industry more so than a private equity organization like Boats Group. But in the Boats Group context, they have in their service just a set of contracts that brokers will use. And they vary very much so. They're very, very different. I had a conversation recently with them, and so they may have gotten rid of this form, but there was an old vestige of a form that used to be around for everyone, which was the conditional acceptance form, it was called. And if you're still using a conditional acceptance form found in the Yacht Closer programs, it actually is a free out, if you will, for the seller. And the buyers don't appreciate that. That form has been completely eliminated from the YABA set of forms, which is what most people will run into. The International Yacht Brokers Association, which used to be known as the Florida Yacht Brokers Association, still has the form, but they've essentially changed it to do the opposite of what it says. It is no longer a conditional acceptance. Now, what does that mean? Why was that? That was a problem. And that's a problem if the market conditions are such, because the buyer will say, well, here are the things that I found wrong. And so I'm going to put in this conditional acceptance form, which says I'm conditionally accepting, but I really want a price reduction. Well, the way that form has always been used until EBA reversed the way what it actually says, and it was disposed of by YABA, it actually created a counteroffer. And if the seller didn't like it, he or she could walk, and they had walked if the market conditions were correct. Meanwhile, the buyer thought, wait, I'm still under contract. I didn't really mean I wanted to walk away. I just wanted a price reduction, and it was a suggested price reduction. Well, that's not really what the form did, and there were several cases where the buyers were greatly disappointed to find that there was someone offering more money with less strings attached, and it gave a free out. That form is still available in the context of the Yacht Closer system that many brokers who are not members of YABA or EBA will still use because it comes packaged with the Yacht World program. And now that form may finally have disappeared. I had some conversations with them recently. So at the time of this podcast recording it, at least I believe it's still there.
Well, thank you so much. It sounds like there's a lot of ways that boat owners need to be aware and look for ways to protect themselves in advance. And that is it for today's episode of Anchored in Law, the Maritime Podcast. To learn more about Todd Lochner, visit boatinglaw.com. You'll find straightforward resources to help you protect your investment and avoid the costly surprises that come with maritime paperwork. Thank you for listening, and don't forget to leave a review, and subscribe to the show so you don't miss the next episode. Thank you, Todd.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.